All right, we're cause number 253-7045, State of Texas versus Emma Lynch. Ms. Lynch was picked up a DWI November 4th of 2024. She was ordered not to...
Right from the jump, this isn't looking good. A bond violation means the court believes the defendant broke conditions that kept her out of jail. What do you think? Should courts be stricter on bond violations, or does everyone deserve a second chance? Let me know in the comments.
Consume alcohol or illegal drugs. We now have a bond violation report. Today's date is February 3rd, 2025. Can you please identify yourselves for purposes of the record?
For the state, Kelsey Siegler. Anna Edie for Ms. Lynch.
Okay, so Ms. Lynch we are here now again. This also is a second bond violation report. The first bond violation was November 20th of 24. We now have another bond violation. It is a report that was filed on the 29th. Okay, State, if you'd like to.
There is slow, you can just give me a moment, but this case is regarding this similar, not of skipping testing as well. And I'm trying to print the bond violation report and the bond conditions, just one moment. What we would call as our witness, pretrial services, Fleischer Stiles, again.
Okay, ma'am, would you come up? Would you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, please.
Thank you, Ms. Childs. Are you able to show us the bond conditions on your end if you have the letter?
Yes, would you like me to?
Yes, ma'am. Thank you. And Your Honor, we would like, if you could please take judicial notice of the file as well here regarding
Sure.
the
Any
defendant
objection?
being charged for this.
I have no issue with the,
Same as the last one.
correct, with the information.
So no objection to taking judicial notice of the file, however, not of the actual report, of the bond violation report.
Quickly. Now we're in murky territory. The judge won't take judicial notice of the bond violation report just yet. That means they're leaving room for it to be challenged. Smart move or unnecessary delay? You decide.
Legal note here: when the judge says they're taking judicial notice of the file, that means the court officially recognizes it without needing more proof. But here's the catch: they're not taking judicial notice of the bond violation report yet. Why not? Because that report could be challenged. Keep watching, this is where things start to get sticky.
Just yet, let her take a look at it.
Yes, sir.
So again, States 1 will be the actual condition of bond report.
Yes, sir. Do you recognize this? Yes, yes. What is this? Bond violation report? Can you please tell us what the bond violations were in this case? Yes. Oh wait, let me actually refresh that. Do you recognize this? Yes. Okay, what is this? Conditions for the defendant. Your Honor, we will tender State's Exhibit 1 to defense for any objection regarding the bond conditions in this case.
Judge, this says that never mind, I misread that. No objection.
State offers State's Exhibit 1 into evidence.
Okay. Will
Ms.
be
Childs,
admitted?
can you please tell us, thank you, Your Honor, sorry. May you please tell us what the bond conditions are listed in this case that defendant Lynch was supposed to abide by?
So December 3rd of 2024, we have defendant to appear in court on time every time the case is set on the court's docket unless judge waives the appearance. Defendant shall commit no new crime or shall not engage in any conduct that could result in his or her arrest. The defendant was required to obtain a portable alcohol testing device that same day, December 3rd, to submit to random drug and alcohol testing, to not consume any drugs or alcohol. And yes,
These are pretty standard for this kind of case, correct?
yes.
Thank you, ma'am. So regarding what's been marked as State's Exhibit 2, what is this?
A bond violation report.
Does this fairly and accurately depict a bond violation report?
Yes.
State tenders defense for any objections.
I would just object to, in this State's Exhibit 2 bond violation report, there's a reference to a number of skip tests. There's no dates on here, so I'm not quite sure which ones, based on the four corners of the document, we're addressing that.
Okay, I guess we'll be getting into that now.
I guess so.
Okay,
State offers State's Exhibit 2.
okay, it'll be admitted.
Ms. Childs, can you please read what the violations were that are overtly obvious in this case?
3 tests a day, strict time slots, no skipping. Sounds tough? Well, remember, these are conditions to stay out of jail after a DWI. Is this level of monitoring fair or overkill? Comment your thoughts.
The client was ordered conditions of bond that included to refrain from alcohol consumption, to obtain and be monitored by portable alcohol testing device, and to comply with required monitoring, testing, service for calibration protocols. The client was instructed to not obstruct the camera on the device and do not skip any testing windows, 5 a.m. to 8 a.m., 5 p.m. to 8 p.m., 10 p.m. to 12 a.m., blow into the portable testing device 3 times a day in accordance with the blow schedule to ensure compliance with the ordered conditions. There was a high breath alcohol content of 0.03 on 1/10 of 2025 at 10:38 p.m. The client blew into the device in the dark and her face was not able to be seen. The client failed to clear the high breath alcohol content in the allotted time. The client is also not blowing into the device as instructed. The client has a total of 15 skip tests.
And tell us what your role is in the courtroom.
A judicial liaison officer.
And you're able to testify to the bond conditions and to the bond violations.
I can testify to the bond conditions. I did not generate the bond violation report myself.
But can you attest to these dates in which the violations occurred?
I have not looked over the report recently, so I don't want to say yes.
But this is the bond violation that you've seen before.
Yes.
Okay. And it is true that the defendant here is on bond in County Court 11-5?
Yes.
I'm sorry, go ahead.
We pass the witness.
Okay.
Okay. Ms. Giles, part of your job is to read the reports when they come in from the case managers?
Yes.
And then you file the bond violation report?
No, they filed the bond.
They file the bond violation
Yes.
report, and then you coordinate the,
Yes,
that with the judge?
action and the
Okay.
review of it, yes.
okay. Are you able to verify the information in the report?
If I have the report, which I should in my email,
Okay.
if I take a look over it, yes.
Okay, but the only way you can verify the report is from the report itself?
Yes.
Okay, so you have no personal knowledge of the machine itself?
No.
You have no knowledge of the software?
No.
And no knowledge of how the hardware and the software work together?
No.
Okay, no further questions.
Okay. Anything further? The witness?
No, Your Honor.
Okay. So she has the first violation, right? This is the second time we have a bond violation, right? The first one, was it that she just didn't get the device, right?
Yes, that's when we were going back and forth on the dates to get it, and we kept resetting the case because she said that she was gonna get it and then she didn't, and then we were gonna revoke her, but then she didn't come to court, so then we sent her again, and then she didn't get the device that day, so then we gave her another chance.
Okay.
And
All right.
Judge, just, I don't think I represented Ms. Lynch the whole time on that, but I think some of the confusion was she was ordered to get the in-vehicle interlock and she didn't have a card.
But you did come at the time to where she did.
Oof. You could feel that coming. The judge is done giving chances. This is the moment the hammer drops. Do you think Miss Lynch was treated fairly here, or should she have gotten one more warning?
Get the device.
Yes, and then
within.
Once Ms. Lynch because I believe the vehicle was damaged in an accident and she was hoping to get the vehicle out and get it repaired. And when she realized that wasn't going to be possible, she got the portable device.
My car's fixed now.
Yeah.
As started bleeding.
Okay, we'll get to that in a minute.
My concern is that it continues to happen. What am I supposed to do? The problem is if I let you go, I'm telling you the behavior is okay for you to do. It's not. We have court orders. You're supposed to follow court orders.
Oof. That moment right there when the judge revokes her bond is brutal. And you could feel it coming. Miss Lynch had multiple chances and still skipped tests and consumed alcohol while on bond. What do you think? Should the judge have given her one more shot, or was this the only fair move? Drop your take in the comments.
Doing what you want to do. That's not the way it works. Look, this isn't, I'll let you talk with your lawyer, but it's there. it's continuing to happen, you're skipping and you're continuing to consume alcohol. I'm sorry, I'm gonna revoke your bond, man. She goes with you.
Judge,
Go back and I'll talk to you.
Anything else?
Judge, since she does have a vehicle, if she makes the new bond, can we switch her from the portable to the in-vehicle?
Yeah.
Okay, thank you.
We are back on the record in cause number 252-6407. State of Texas versus Sierra Torrance. Please, guys, if you announce yourselves for the record.
State Kelsey Stiegler.
The state, William Thomas.
Anna Edie for Ms. Torrance.
We have reset this thing at least 4 different times, I would imagine, because of this bond violation. One, I guess, evidentiary reason for Ms. Edie to get evidence. Last time we were here, we were going to have a hearing. Unfortunately, we didn't have our pretrial services officer here. She's here now, so that's why we're having this hearing now to determine whether there is a true bond violation. Ms. Torrance is on bond for DWI that was initially filed August 28th of 2024. It's a second offense, so she was ordered to obtain a guardian interlock, or if she was not going to drive, obtain a portable device, and to blow in this portable device as according to the below schedule. Our first bond violation report was filed October 8th of 2024. And I'm correct in saying that no action was taken on that bond violation.
She was admonished and.
I admonished her. We did not do anything at that time. We now have another bond violation report that was filed January 24th of 2025. And in this bond violation report, we have 13 skip tests on random days. And then I think that there were other issues as well, but I guess for me, the main concern would be that she's not testing when she's supposed to. The floor is yours, Ms. Edie, if there's anything that you wanted to say.
Okay, well, let's see. The only thing I see alleged in the bond violation report is just the skip test. So I just want to make sure we're all on the same page. I don't know that there's any other allegations.
Okay.
That's correct. Okay, okay. This is not my hearing, Judge, so I don't, if the state wants to call somebody or, you know, they have the burden, so whatever they want to do, I'm happy to respond, but this is their.
Your
So
Honor?
tell me what happened with the missed test, if you don't mind.
Yes, Your Honor, we can call pretrial services Miss Fleischer if she is available for one moment.
Okay, do you mind coming up? Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay? State.
And
Judge, would you please take judicial notice of the court's file, which is a copy of the information?
Okay. Any objection?
I'm okay with the information. I would object to taking judicial notice of the report.
Okay.
So I'm not sure what all is included in the file.
we were addressing about the defendant here being charged. That's why we're asking for judicial notice of the court's file regarding that element that we need to prove today.
Sure.
So,
All right, Ms. Chiles, Giles, apologies. Is the defendant on bond or court law on the bond?
Issue?
Yes.
Yes.
Are you familiar with the bond conditions?
Yes.
Your Honor, may I approach?
Yes, sir.
Is this a fair and accurate representation of the bond conditions for the defendant?
Yes.
You recognize that?
Yes.
What is it?
They're the magistrate's conditions for the defendant.
Similar to the defense, Your Honor?
Okay, please. Any objection?
No objection.
Okay, they'll be admitted. States one, I guess?
yes, sir.
Okay.
Could you please describe the bond conditions?
Yeah, you want me to read all of them? Or like all of them?
Yes, we don't have an objection.
Yes. So we have defendant shall personally appear in court on time every time the court, this case is set on the court's docket unless judge waives the appearance. Defendant shall commit no crime or shall not engage in any conduct that could result in his or her arrest. We have here that they're to obtain an ignition interlock device within 7 calendar days. Is this the most recent bond condition? Doesn't she have a portable device? The device. Are these the most recent conditions? Because these are the IID ones. Can I have a moment to look them up?
Sure.
Yes, please. These are not the most recent bond conditions that have been placed. These are the first ones from the magistrate. Right now I'm printing out the amended bond conditions that were created on September 4th, the ones that we're referring to with the portable device. So the first two conditions are the same that I had stated. However, instead of the ignition interlock, we have the client is to obtain a portable device within 7 calendar days. And that would be from the date of August 28th. And then no driving without permission of the court. We have no drug or alcohol usage. And then that same day, the defendant also was required to submit to a POC test and return to court.
Your Honor, would you like me to consider these updated?
Sure, of course.
With amendments?
So two, I guess states 2 would be the amended conditions of bond.
We're calling this stage 3, if that's okay, Your Honor.
Okay, sure.
I have no objection to this.
Okay, it'll be admitted.
Now we will be addressing the bond violation report.
Your Honor, may I see the witness?
Sure.
You recognize that?
Yes.
Is that called?
This is the bond violation report?
Is that a fair and accurate representation of the bond violation report?
Yes.
All right, could you please explain the violations of?
Objection, she's reading from something that hasn't been admitted yet.
Mistake, Your Honor. I'd like to consider this to the defense.
Oh,
This will be admitted as State's Exhibit Number 2, Your Honor.
Okay,
no objection.
all right, it'll be admitted.
Can you please read where it says details of the violations indicated here?
Yes, the details read that the defendant was instructed to obtain a portable alcohol testing device and refrain from alcohol consumption. From December 9th to January 14th, the defendant has generated 13 skip tests. Pretrial is unable to properly supervise the defendant if the defendant is failing to provide samples during the scheduled timeframes.
Wasn't it a condition of bond to complete those portable tests?
Yes,
And how many again were not completed or were missed?
13.
And what were the dates?
Between the dates of December 9th and January 14th.
Thank you.
Any further questions for the witness?
No, Your Honor.
Okay.
Do they prepare a report of the missed blows with the specific days?
Yes, and that was provided to everyone here's email last week or the week before when we had discussed it.
Okay, Ms. Giles, what is your job title, exact job title?
Judicial liaison officer.
And what do you do as part of your regular duties?
I am the face in the court for pretrial services, so I create bond conditions that are requested from judge and instruct clients over things that I can instruct over, so conditions that don't require devices in court. And if not, I send them over to our pretrial services building for further instruction.
Okay, do you know how the portable device works?
I'm very partially familiar, but not thoroughly, no.
Okay, do you know how the software in the device works?
No,
And do you have any idea how those work together?
no.
So when you get a report, you have no way of verifying whether that information is accurate.
The vendor sends us the full report to our case managers.
And was the full report provided?
Okay, now we've reached the showdown. This is where both sides get to lay down their arguments. But keep an ear out because what the defense says next throws a curveball into everything. Do you think the machine's accuracy should decide someone's freedom?
In the email that you referenced earlier?
Yes.
Okay, but there's no way to know that that device is working properly from your personal knowledge.
For me to validate if it's working correctly, me personally, no, but our case managers do verify it.
Okay, I don't have any further questions for this witness, Judge.
Okay. Anything further?
No, Your Honor.
Can the witness step down?
Yes.
Okay, thank you so much. All right, I guess argument. Or do you have any more witnesses?
No, Your Honor.
Do you have any witnesses?
I do not.
Okay, argument.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in County Court at Law number 5. And we just discussed the bond conditions.
Whoa. The defense throws down the gauntlet. Should a bond be revoked if there's doubt about whether the testing machine was working? This argument could change the entire case. What's your take on tech deciding someone's freedom?
They were pretty standard, and the violations here very clear that there were 13 missed portable tests, and our pretrial services was able to confirm that, and we would ask that you would revoke the bond in this case.
Judge, this is, the rules of evidence apply at this hearing. This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this to today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs, as with
Yes,
regard to
Your
this,
Honor.
not anything else.
Okay,
All
well-
in-
And
Okay,
we
go
would
ahead.
say that the defense also has the ability to subpoena as well.
And this was set on Thursday, and it's also not my hearing, it's not my burden. I think without someone to testify that the machine was working properly, it's inappropriate to revoke her bond, restrain her liberty, the pecuniary punishment that goes with the bond revocation and paying a new bond, without knowing that the machine was working properly.
But that's on them. If there's a problem with the machine, then it's on them to go have its service or whatnot. So
Does she know it's
all I
working?
know, it's, well, then you're supposed to go there. You're supposed to go get it checked out. We can't micromanage every single thing. Number one. Number two, this is not the first time we've had this bond violation. We've had it before, and it continues to happen. I can't just let it go, man. I mean, I have to show you that we mean business. If I let you go now, then I'm enabling this behavior, and I'm in effect telling you it's okay when it's not okay. You're skipping tests. It's a second offense. It's done. All right, I'm revoking her bond. She goes with you. It doesn't make me happy to do it, but I mean,
I
it's
understand.
bond violation after bond violation.